All right, here we are again. Welcome, everyone, to another edition of Insights. My name is Bob Wright, and my telephone number is 206-619-3274.
And I am Mike Walsh, and my phone number is 310-383-1570.
Hey, we got a lot to talk about, Michael.
Yeah, the legislature just enacted three bills, House Bill 1236, House Bill 1368, and Senate Bill 5160, all of which will impact the residential rental market and landlord-tenant laws. So with the new complexities, we figured we'd talk to the expert.
And so you're talking, of course, about Chris Benis, legal counsel for the Rental Housing Association. We had a nice conversation with Chris.
The big change is that any fixed-term lease, automatically goes month to month, okay? And there's a mechanism to try and keep people on a fixed-term lease, although I don't even know if that's worth the effort for your average landlord to want to do that, So I think, again, for a lot of smaller landlords like me who own single-family homes, trying to think about renting it out in big chunks of time, is pretty much going to go out the window. For, again, larger property owners, maybe in the 20-unit and up category, most of which let tenants go month to month, it ain't going to be that much of a difference.
Right.
Other than some of the termination periods are extended.
What type of impact does this have on rent increases? For instance, if at the end of a year lease or a 6-month lease or however it's written, the landlord decides to increase rent X amount, or that might have been the reason why the tenant might not have renewed in the first place. Are you still? Are there? I guess what I'm trying to figure out is can landlords be shackled into an agreement that they signed 3 years ago when the market was entirely different?
Well, they can raise the rent, but, there's a whole bunch of little quirks in there. Like, okay, I'll be honest with you. It has been a bit of a dirty secret that, and I even know some of my broker friends who've done this, who, they get around just cause by raising the rent an extreme amount until somebody voluntarily agrees to get out of there, and that's sometimes called an economic eviction. Mm-hmm. That's not going to fly because one of these there's language in here that says that if your notice of rent increase isn't reasonable, well then it's not going to be enforceable. So there's going to be this overarching opportunity for a tenant to challenge. Well, I think you raised it too much. How much is too much? I don't know, but maybe the consensus is going to be anything more than a 10% increase might be, interpreted as some backhanded way of getting rid of tenants outside of just cause.
What about the buyer who buys a building with the purpose of rehabbing and they want to give tenants notice? How is that going to be different?
It really isn't for the people in the city of Seattle. You're still going to have to go out and get a tenant relocation license, and that's going to take, 6 months or more. And, it's going to be a process. I think the harder point is trying to make, tenant relocation assistance ordinance, TREO, in the city of Seattle mesh with this 120-day notice to terminate for a purpose of rehab that's in the state law. And it'll be real interesting to find out whether or not the interpretation is going to be, well, when you get to the whole end of the TREO process, is it a 20-day notice to terminate, or is it 120 days notice to terminate, kicking the whole thing out another 4 months? I don't know.
What about if a landlord wants to move a tenant from Unit A to Unit B because something is wrong with Unit A? Maybe there's a sewer line that has backed up, and can they force the tenant to move, or is the tenant locked into there's a tenant control?
Well, here's the funny thing. Most tenants cooperate, and most tenants want to live in a unit with working utilities, and most are happy to be temporarily relocated, and it happens on a consensual basis. But forcing somebody out because of a problem like that is almost impossible. And what this particular state law says is that you've got to be you have already received a shutdown order from the city, and even then you've got to give them 30 days notice to terminate on top of that.
So if it was a cosmetic rehab, for instance, and you were going to find them an equivalent 1 bedroom somewhere else in the building, and the tenant said no, basically that's the end of it. The tenant has the trump card on that type of scenario.
Unless you go out and get a tenant relocation license, which is going to be again somewhere I think upward of 6-month process. Sure.
There's a lot of language within all these 3 bills that sort of, allude to, you hear reasonable a lot, and it's almost up to the landlord's interpretation to either be reasonable when it comes to circumstances surrounding payment plans, because of COVID, or, reasonable when it comes to, various other aspects of these. It's for a mom and pop or a smaller operator that's not really a comforting word and is quite ambiguous. How do you see that playing out in the real world if it gets to that point? I mean, is this going to take a lawsuit to?
I want to say 2 things. One is that managing rental property is becoming harder and harder and harder, and really is something that needs to be left to professionals unless you're a professional yourself. I think you're going to see fewer and fewer small buildings self-managed by its owners. For those who choose to do that, I think they're going to really have to rely on groups like the Rental Housing Association of Washington, RHA, of whom I'm a legal counsel still. We still have, we've been running like crazy, improving our forms, making them compliant with these new laws so that landlords can, do just that, comply with the law. But it's sort of like a lot of things in the world. You don't know what you don't know. And so unless you live and breathe this stuff every day, like a professional property manager does, there's going to be just tons of opportunities for people to stub their toes.
Let me ask you this question. Once COVID goes away, how difficult is it going to be for a landlord to raise rents?
Well, I mean, first of all, right now we don't have rent control in the state of Washington, and maybe we will and maybe we won't. But, there's still a ability to raise rent, and I believe that rents are going to have to go up so that people can offset their additional costs and their additional risks. So if you're just a small landlord, let's say you're an investor buying a 4-unit apartment building, I mean, you guys do, income calculations for your potential clients. And if they have to factor in professional management, that really hits the returns, particularly on a smaller building. So either the value is going to go down, the sales price is going to go down, or the rent's got to go up.
But these new laws, but the effect of these new laws, is it going to be more difficult to raise rents because of these new laws, Senate Bill 5160 and HB 1236?
I don't think these particular laws themselves will impair landlords' abilities to raise or adjust rents unless they just get caught up in a procedural screw up or something like that. These aren't meant to limit rent. They're meant to eliminate terminations of tenancy and to provide some processes to deal with those tenants who haven't been able to, pay their obligations during COVID. So, I don't see these as keeping rents down. I see these as raising costs.
Does this more or less lay a foundation, though, at the state level for an individual municipality to go in and add on, for lack of a better term, if for instance, a city decided that and I'm sure this would have to be legal and it would be challenged, but upon upon turnover, upon lease termination, rent can only go up 2%, 3%, 5%, something along those lines. If it's more difficult to move a tenant out for whatever reason, are you basically piecemealing together a rent control ordinance?
Well, a couple things. Always recognize that some sort of eviction control, eviction limitation, like this just cause eviction that's in House Bill 1236, is a precondition to rent control. If you can just get the tenants out without any reason, that's usually a workaround for rent control. So in cities all around the country, most of the time, the way one gets around rent controls is by getting rid of the tenant somehow. But, so I think this is a precondition to that. Do I think that at some future date there'll be a serious run at removing the statewide preemption on rent control? Absolutely. I mean, that'll probably be the next battle because, the only thing that prevents rent control right now, it isn't some constitutional thing. There's a state law that says cities can't have rent control. So it's a one sentence law. If that got repealed or somehow watered down, where let's say cities above a certain population could have their own rent control laws, then you guarantee it's going to happen.
But that also affects the farms in eastern Washington, where some of these farmers lease out their fields, does it not?
Well, no, because farmers leasing out fields is doesn't fall within the residential property rent control. Interestingly enough, you may not know this, but there's only a prohibition on residential rent control in the state of Washington. If the city of Seattle or anybody else wanted to have a commercial property rent control, they could.
The only other question I would have, and if you don't, Chris, if you don't want to get into this, that's totally fine. But as far as the LMP, the landlord mitigation program, if somebody were to seek out, try to recoup some of the rent that they lost over the course of the pandemic, what's sort of the first step or the initial step of going about that process?
Well, the first step is to really try to paper your file that you're offering the tenants a reasonable payment plan. And of course, reasonableness is something that can always be argued. So, you should be inviting the tenant to say, okay, well, tell me your problems. And okay, well, I'll factor those in, and here's a reasonable payment plan. And do you agree to it? And, if for some reason they don't, well, then, that is a exception that allows you to start going out and doing some collection. But the burden's on you as the property owner or landlord to say, we did offer them a reasonable payment plan, and they refused to agree to it. And so what I'm hearing, and this isn't really a space that I work in very much, but I'm just hearing from other colleagues, is they're saying they're putting all their efforts into trying to engage with folks, trying to get them on payment plans, no matter how little money they're paying or how long it's going to take them to pay, do something to try to get them on a payment plan.
Got it. And keep meticulous records, it sounds like.
Yeah. The world. Yeah. Like I said, I think not that much is going to change with these laws for the larger property, the one that's in some level of professional management. But I just think that, like for myself, as an example, I used to own 5 apartment buildings, of which you guys helped me sell one of them. And I've sold 4 of them now. I only have 1 left. And, I, with all my knowledge, maybe because of all my knowledge, I've said, this really isn't a space where I want to be investing. And so I'm still a real estate investor, but I'm not owning residential rentals, and I'm not owning them right around here.
Yeah. Were these bills modeled? I know a lot of times Washington takes stuff from California or various other places. I mean, is there another state we can look to and that's maybe had some of these bills in effect for 3-4 years and sort of see it plays out like that? Or is this a homegrown product that we really don't know what it's going to look like a few years from now?
Well, the concept of, just cause eviction is exists in different places around the country, particularly in places like LA, Chicago, New York, etc. Again, pretty much any place with rent control, number one, probably has some form of restrictions on terminations of tenancy. So it might be hard to look at which ones just have restrictions on terminations of tenancy but not rent control. But yeah, I definitely think that the folks who are behind these laws are patterning them after models elsewhere, and I definitely believe that it will be more challenging to run rental properties here, but that doesn't mean, again, the rental market's going to go away. You could buy rental properties in New York, LA, Chicago, Boston. Those are still viable investment markets. It's just going to require a different kind of person and a different level of commitment to do so successfully.
So is that why you say that it affects the smaller property owners more than it affects the landlord that owns 20 or more units because of the paperwork and the legal steps involved?
Right. I mean, if you were somebody that owned a duplex or even a 10-plex, and trying to manage it yourself. I'm not saying it isn't doable, but it's going to require a level of commitment and a level of knowledge that just wasn't required in the past. And so, I mean, for my larger clients, the hundreds and up, management companies or investment groups, again, maybe they even have in-house legal counsel, or if not, they're hiring folks like me to go in and give seminars to their employees and help them with their policy manuals and make sure their forms are up to date. People who used to do this as along the side of being a Boeing engineer, and whether they're a member of RHA or just downloaded some forms on the internet, those people are going to be in for a world of hurt.
On that note, I am a member of RHA, and I just have a question outside of that. This came up the other day for tenants that have been longer term, 3-4 years maybe. Would you advise having them sign a completely new lease with a full lease, given how many changes have taken place, rather than just a lease extension with the baseline lease being maybe a couple years old? Does that make sense?
Yeah, I think that's a good idea. When the landlord tenant law changed a couple years ago, we offered a cleanup addendum to kind of bring those compliant, because people would have a lease that says, well, you can do your security deposit accounting in 14 days, but it's now 21. And, you used to say you could raise your rent on 30 days notice, but now it's 60. And so, I don't know if we're going to offer a cleanup addendum, and if we do, I'm sure it'll be comprehensive. But either way, you're probably going to want to make sure that the agreements with your tenants are sort of transitioned to ones that are compliant with current law. So the quick answer is yeah. I'd use the opportunity, particularly if you're already on fixed-term leases and you're going to do a renewal where the tenant's going to sign on. I would definitely try to get them on a new form.
Thank you, Chris.
By the way, RHA did kind of change the entire paradigm of how their lease forms work. We used to have a single family and a multifamily lease, for non-Seattle, and a single family and a multifamily lease for Seattle. And now we've gone to a different model of having a month-to-month agreement, single family and multifamily, and a fixed-term agreement, single family and multifamily. And then we use separate addenda to deal with local municipalities. So that's another thing we need to be aware of, is so many local jurisdictions, not just Seattle, but Tacoma, Federal Way, Auburn, Burien, are adopting their own set of unique landlord-tenant laws. Even Kenmore has got its own landlord-tenant laws. And so rather than have new and different lease forms for every little city, we're going to have, the standard document and then sort of a amendment addendum for each jurisdiction, because that's sort of going to be the wave of the future. And that's something to really keep in mind. Again, Seattle used to be the outlier with its own landlord-tenant laws, and that doesn't appear to be the case moving forward. Everybody wants to get into this, even cities that you might consider, not sort of leftward leaning, Kirkland, places like that say, gee, let's look at having our own landlord-tenant laws.
Yeah, this has been great.
Sure.
Chris Benis, everybody. Thank you, Chris, attorney for the Rental Housing Association. Insights is the name of the program. I'm Bob Wright, and my telephone number is 206-619-3274.
And I'm Mike Walsh, and you can reach me at 310-383-1570.
And give us a call if you have any questions or if you want an analysis on your property. We're pretty good at that. Again, telephone number, Bob Wright, 206-619-3274.
And Mike Walsh, 310-383-1570.
Insights, the name of the program.